Hello and welcome to a new episode of Interpreting India. From geopolitical complexities to economic uncertainties, India faces critical challenges in its quest for a more prominent role on the world stage. This season, we at Carnegie India continue to bring voices from India and around the world to examine the role of technology, the economy, and international security in shaping India's future. I am Nidhi Singh, Associate Fellow at Carnegie India. Today, we are talking about something that touches almost every part of the digital economy in India right now: data protection and AI governance. India's digital personal data protection rules came into effect late last year, and the enforcement architecture is still being built out. At the same time, the conversation around how to govern AI is evolving rapidly. India has so far chosen not to go to the route of standalone AI law, but the questions about liability, risk, and regulation are only getting louder. Joining us today to discuss all of this is Nikhil Narendran. Nikhil is a partner at Trilegal and a part of the firm's technology, media, and telecom practice. He focuses on the interplay of technology, human lives, and commerce, and advises new age e-commerce, fintech, and technology companies on regulatory issues, including data protection. He also heads Trilegal's Digital Innovation Group, which is leading the firm's own adoption of AI, something we'll definitely get into in today's podcast. Nikhil, welcome to Interpreting India.
Thank you, Niti. Thank you for having me here.
So let's start with data protection. The DPDP is now law, the rules are in place, and the companies are figuring out what this means for them. One thing that stands out about the DPDP is how heavily it leans on consent and the basis for processing data, much more so than the GDPR, which gives companies other grounds like legitimate interest. So for an average user, that probably sounds like a good thing, but in practice, does it create more problems? Are we just headed for a world where there's even more consent fatigue and people just keep clicking on I agree without reading anything?
Yeah, so Nidhi, I'm sure that users will continue to click on I agree without fully reading what's going on. But I would like to clarify that, look, it's actually a misconception about the Data Protection Act that it is heavily reliant on consent. You can say that, look, at least 50 to 60% of intensive users of data, personal data, you would have to probably rely on consent as a means for data processing. But it also has several other legitimate uses. It may not be exactly the way in which GDPR has dealt with it, in the sense that GDPR has a test that you need to follow. If it's for particular purposes, a company can take a call that, look, I can process this personal data so that I'm not causing any harm. I've taken certain measures, internal recordings, etc. But the way in which the Indian law deals with this is slightly different. For instance, Indian law, allows processing for employment-related purposes without any consent, right? Which means that large number of Indian IT outsourcing units or service provider IT companies, the likes of Wipro, Infosys, TCS, etc., do not need to take consent, right, to process their employees' data. For instance, there are other exceptions as well available. And one interesting use case that India has, which is very different from the rest of the world. In fact, I would say it's sort of a very nice little jugaad that the Indian regulators have done, which is that they've come out with this provision called voluntary provision. So if you're voluntarily providing data to a particular company for a particular purpose, it cannot expand to large number of purposes, then you can just simply put the person on notice of the fact that you're collecting the data and process the data. Some of the examples include, for instance, you're going out to a website and filling out a survey. You're voluntarily giving that information, and provided that the survey information is used only for, what the purpose of the survey is, a company need not rely on consent. So I would say that, look, it has several other ways in which you can process the data. The other exception is, of course, if you're using it for prevention of crime, the Act does not cover that particular purpose, which means that large number of CCTV use cases will get covered. So it's true that for a large number of aspects, the personal data needs to be processed on the basis of consent. But at least I can think of at least 30 to 40% of instances where companies can also rely on similar exceptions to process data on these narrow grounds. So would the reliance on probably around 50 to 60% of use cases on consent cause friction? I would say that if you are involved in the process of heavy data processing, for instance, you're collecting it for analytics, you're collecting it for purposes other than that's obvious to the consumer, for instance, for AI-related purposes, even the CCTV camera is then used for face tagging and identification of user at a later point of time, you would need consent. At those times, I would say that, look, consent is probably the only meaningful way to process the data, because that's when the data principal would be fully aware of the fact that what is data is used for. So in that sense, I think the law has struck a reasonable balance. And for some reason, we have gone with the narrative that, look, it's such a consent heavy law. I would say that it is not necessarily so.
So only the requisite amount of I agrees is what we'll get.
I think so. I think so. And look, and at some level, we are also used to clicking I agrees, right? So I always say that, look, in India, we don't understand consent very well. The concept of consent is not fully understood in India, at least at this point of time. So we've been clicking a lot of I agrees all throughout our life, and we'll continue to click a lot of them. And in fact, the beauty of it is that now we'll also see instances where if it's made aware to the person, if a simple CCTV notice is put there saying you are under surveillance, you don't need an I agree button. Or if you're entering a campus where your Face ID is being tagged only for the purpose of recording your entrance, there is no need for a particular consent if that data is not used for any other purpose. So in that sense, the act is quite innovative. And I would still say that the I agrees will continue to remain. In fact, we will have more opportunities to reduce the I agrees that you see on the digital.
No, that's good to hear. So you've touched on AI, which we'll definitely get to in a while. But the other thing that you've talked about is how companies are dealing with this. When it comes to companies, because you work with founders that are building products in India, you work with fintechs, e-commerce, new age tech companies. Something that I'm really curious about is data governance something that they are thinking about maybe earlier in the process now? Or is it still coming at the very end when everything is done and then somebody says, oh, we need to be compliant?
So look, there are different sorts of founders and promoters that you incur while we work with them. But I would say that a large part of them treats privacy as a part of the trust building process with the consumers. So though they have a good, reasonable understanding of privacy and the fact that, look, they cannot play around with the trust of the customers. Whereas, look, there is an equally other side number of promoters that I've seen who are not, it's not top of their mind. It's not like they're sort of avoiding it deliberately, but it's not top of their mind because they are naturally thinking about other things, including how to increase their revenue, how to scale much faster. So in that sense, they may not be thinking about data governance in the same aspect. So even pretty much most of the founders that I work with, most of them are aware of it. At least for some of them, it's top of their mind, especially when they are building products which face the consumer. When they rely on large amounts of data for carrying out their activities, they are aware of these aspects. But I have not seen very robust data governance practices within these companies yet. And that process will only start with data protection implementation. And it's actually, it started. We've started seeing this change yet, in the sense that a lot of folks are talking about it. There's a lot of importance given to data governance amongst the founders. And in fact, I can see that difference both in, I work with a lot of founders in both NCR and the Bangalore region. And I've seen this change across a lot of them. And I'm sure that maybe after 6 to 7 months, you will see a sea change, because they all understand that what a penalty under data protection law, or what a sort of a negative implication in the mind of a customer would lead to, right? Because ultimately, consumer trust is really the key when it comes to digital business, especially if you are in the B2C side, right? So data plays a very, very significant part there. And I'm sure that we will see a sea change in the way in which founders approach the issue of data governance.
No, that's really good to hear. It's good to hear that you can see this evolution that's happening and that people are thinking about this earlier on in the process. I want to switch tracks a little. So it's good to hear the company perspective. But let's talk a little bit about regulatory design, because you are uniquely positioned to talk about what the regulatory design looks like. So the DPDP, it sets up a fairly elaborate structure of different stakeholders. So you have data principal, the data fiduciary, data processors, consent managers, the data protection board, and then you have a government that sort of sits on top of this. On paper, that sounds really good, and there's different sets of obligations and they all kind of work together. But when you look at how they kick in, because there's a staggered approach to when all of these sort of come into play, the consent managers don't really register until the later half of this year. How does this design hold up? Like, what do you think of what the regulatory design under this regime looks like?
So the regulatory design of the DPDPA is at some level, it's been very, very carefully crafted because we have seen the regulatory design of DPDPA change over the years, right? Right from the time when Justice Sri Krishna was drafting the law, all the way to the bills that the government came out with, to various versions that we have seen over the years. The design changed completely from a very GDPR-like law to something else, whereby a lot of clarity is to be legislated by way of rules, taking it out of the hands of the parliament and giving it to the executive to use those power responsibly. So, in that sense, I would say that look, the real important stakeholder in this equation when it comes to the regulatory design is the government itself, right? How responsibly is the government using this its power to make a large number of rule under the act, which is how it will be implemented. You talked about the implementation, the timeline, etc. So it really depends on how fast the government acts, how well the government acts, who is going to be the first data protection board, who are going to be its members. So I think it is really up to the government to act in a responsible manner to ensure that the regulatory design is strengthened right from the time of inception of the board, because we'll need best of the folks to work on and be a data protection in the data protection board. We want a timely appointment. We want timely further clarifications and rules to be issued. We want timely consultation with the industry and stakeholders. So I would say central government is a key stakeholder. And at the same time, look, that's also a flaw of the DPDP in the sense that, look, in the scheme of things, government is probably one of the largest data fiduciary, but they actually have the least amount of obligations under the Act and probably the maximum amount of power under the Act as well, including calling for information and the rule-making power. Like you mentioned, I don't know if you know about this retention rule under the DPDP rule, which came out recently, which is now mandating that even privacy-preserving technologies which auto-delete data within a set time frame, whether it's your voice assistants, which may delete data after a couple of hours, to CCTV cameras, which may delete data after 72 hours, you need to preserve those personal data forever, which is creating a data maximization regime, right? That's probably an example of a responsible use of this rulemaking power. Whereas there are other good examples of responsible rulemaking under the DPDPA that we already see. And in the scheme of things, unfortunately, the data principle has the least amount of rights and powers, because we also don't have a right to receive a compensation. Despite the fact that, look, right to privacy is a fundamental right, you don't get a compensation for a data breach per se. Though interestingly, there is a very unique mediation provision which is there in the DPDPA, which we are still grappling with to figure out what that really means. So in that sense, I would say the regulatory design is such in designed in a manner where government has a lot of powers. And they also have responsibilities, not as someone who processes data, but as someone who's administering the whole design, a regulatory designer.
Thanks, Nikhil. So you've touched on the right to privacy and compensation. And I feel like this gives me license to ask you a slightly more difficult question that we've been thinking about. So 2017, the 9-judge bench in Puttaswamy reaffirms your right to privacy. After that, you have your entire conversation around data protection. The bills come in play. You have several iterations of it. A lot has changed in the world since this conversation started. You've talked about some of it already. So one of the things that you've seen coming up is just how much damage that this sort of data can do. So when you look at the 2017-2018 era, you also see that Cambridge Analytica was something that was happening around that time. So if something on the scale of Cambridge Analytica happens in India tomorrow, a massive systemic misuse of personal data that's being used for either political or commercial manipulation, what would you do under the current iteration of the DPDP Act as it stands? Do we have the institutional muscle for something on that scale, or would we mostly be set up to hand out fines after the fact?
Yeah, unfortunately, this is probably one of the most important and interesting questions that one should be asking when we are discussing DPDPA. Unfortunately, the bill is really toothless. The act is really toothless when it comes. I've been saying bill for almost like 10 years now in my life, so pardon me for that. So the act is really toothless when it comes to handling these situations. Like you exactly said, look, the board can hand out fines. The board can probably block the access. but at some level, the damage will really be done, right? Though the board has a power to investigate, there is no real deterrent under the act which stops a bad actor from doing something like this. And it is quite unfortunate that look, even the previous iteration of the bills had certain provisions when it comes to re-identification of data, etc. There were some penalties. There were some aspects which were there in the bill to address such Cambridge Analytica like scenarios. But unfortunately, the current act doesn't have any such provision, which means that look, a errant company or a company which may want to sort of push the envelope and use aggressively a systematic targeting and misuse of personal data of Indians can go unpunished. And look, the thinking and the reason why the government did that is the thinking often in the circles is that look, we need to have ease of doing business, so we don't want laws which penalize the corporates for doing something wrong. But unfortunately, that's been stretched to a large extent here, because we're not talking about somebody getting a fine for or going to jail for not filing a form, or for something which is trivial. We are looking at an extreme offense, which unfortunately the bill does not penalize or criminalize, which is a missed opportunity. And look, some may argue that, look, we don't want a situation where every data breach should actually land up in a police station. Fair enough. That's a fair point. But we already have an existing design in our Aadhaar Act. If you just look at the Aadhaar Act, even if our Aadhaar data is, let's assume, to be misused by someone for criminal purposes, you and I cannot go to court. Instead, it's the authority, it's a UIDA which has got the power to register a police complaint. A similar sort of a design could have been brought into the DPDP with adequate criminal punishment, so that the companies do not just put a monetary penalty as another amount that could be added on to their balance sheet at the end of a financial year, and instead would be feared in terms of doing deterred from doing an activity which is illegal or criminal. And in this age of AI, right, I think it's a missed opportunity, and we should really consider bringing an amendment to bring such a clause in with all the adequate safeguards. Like I said, look, the idea is not to kill the digital business. The idea is to ensure that there are bad actors in the world, and we need those bad actors to be deterred by way of good laws and good enforcement.
I think this is as good a place to shift gears. We've covered the DPDP Act, what it does, what we hope it will do in the future. And I think the conversation can now turn to AI, because a lot of the data protection questions that we have start running into AI really quickly.
Absolutely.
Because of course, the DPDP governs personal data, but so much of it is now being collected and used and involved in AI system. So let's talk a little bit more about AI governance. So I'll start with the contentious statement. You've said that India may not need a separate AI law, and that the existing laws like IT Act and consumer protection frameworks can handle the most of the AI related harms that come up if they are enforced properly. It's a fairly confident position, but can you make the case for our listeners for why a new law is not the answer, especially when the EU has gone ahead with the AI Act and there's a lot of global momentum now towards dedicated AI legislation?
Yeah, so I think, look, Nidhi, it's a valid question. And look, let me just start with saying that, look, the reason why there is a strong recommendation not to have an EU AI Act like law is, look, we may not necessarily need to come out with an ex ante mechanism per se to govern a technology per se, right? And there are multiple reasons for it. And I would say the first reason is that, look, we don't fully understand AI, right? Even when EU AI Act came into force, it was talking about certain number of flops to be eligible to be a general purpose AI, which is bound to be a higher category of regulation. But when DeepSeek came out, DeepSeek was not in the definition. Right. So technically, DeepSeek probably would not be covered under the definition of higher threshold regulated AI under the EU AI Act, right? Because it's too early. And we're just talking about Gen AI. We are probably talking about predictive AI, but there is kinetic AI. There is all sorts of different dimensions of artificial intelligence which are being developed. And right now, when we talk about AI, we're just talking about generative AI, which is just, a generation of words, prediction used on patterns, etc. But there are all sorts of different forms and uses of AI which we are not even contemplating. And even if we were to start legislating at this point of time, I think given our legislative pace, we'll at least take around 5 to 10 years to come out of the legislation. At that point of time, the AI would be in a very completely different shape that you and I cannot even recognize at this point of time, right? So, and just to remind you, probably the DPDP discussion started right around the time you were in college, and and now we have the act in force, though it is not fully in force, right? That's the amount of time that a country like India will take to come out of the legislation. So before that itself, there could be harms caused by the AI, right? Before that itself, there could be issues caused by the AI. So if you're waiting for that act to come out, then how do we go and solve these problems, right? So the legislative process in India is so long. Let's try and come out with our own ways in which we can deal with the harms caused by AI, which could be by way of introducing new amendments under the existing laws. Sometimes even amendments are not needed because our laws are so good in the sense that the Information Technology Act, if you look at a particular offense such as obscenity, whether that obscenity is generated by Gen AI or whether it's done with your camera, the IT Act covers it, right? Similarly, the Bharatiya Nyaya Sanhita also has large number of offenses relating to hate speech, causing enmity between races and people of religious ethnic groups, etc. So large number of content related offenses are already handled by these sort of specific statutes. So let's just look at enforcing these well, because we have an enforcement problem. We don't have a problem of not having laws, right? So let's focus on enforcement. Let's strengthen the enforcement. Let's spread awareness about what's happening. If there are sub-legislative tools that we can use to combat some of these issues. For instance, if an IT Act requires an amendment, or an IT Act Section 79 rules require an amendment with respect to synthetically generated content, let's go ahead with that, which is exactly what the government has done to deal with the issue of deepfakes, right? So let's take these approaches. Given the fact that we are a very different society, we don't have the regulatory enforcement mechanism, we don't have the state capacity to go and legislate and then come out with enforcement of that legislation. And look, my experience is that, look, even after Shreya Singhal struck down 66A, right, for close to around 6 years, Indian police stations used to book people under 66A. Right. Then the Ministry of Home Affairs had to just even issue a clarification saying that, look, you cannot book people under 66A, it's gone. Right. That's a level of lack of percolation of laws which happen in the country. Right. So we should be focusing elsewhere. We should be focusing on identifying the harms and try and preventing those harms from happening. Dealing with the scale problem that AI poses, instead of coming out with a large omnibus regulation like EU AI Act. Even if we had, we wouldn't know what to do with it because we don't have the time, money, or the resources to enforce something like this. And even if we were to do it, that very thought itself could put doubts in the minds of the promoters and the founders who are working in the AI space with respect to, a lot of confusion in their minds with respect to whether they should be coming out with an AI product or service. So we cannot afford to lose that opportunity, even from an economic perspective. So that's why I said, look, I'm all for regulation, but a meaningful regulation. But coming out with an ex-ante regulation is an omnibus regulation which introduces a lot of compliances and introduces a lot of form filings. Look, we have enough laws, including our labor laws, by which people can file forms. Why do we need to give people more laws where they just need to file more forms and do compliances, right? So that's precisely the thought point why I would say that.
No, that's really interesting. We do have a lot of laws. I think next year will be 10 years of the privacy judgment as the data protection still slowly cooks into gear. And then another thing that comes up is this, that the form of harms does seem to be evolving a little. So one of the things that I really find interesting about your work is that we've talked about regulation, but you don't just do regulation in a traditional sense. So you wrote a piece for the Indian Express, which I really like. And it talks about AI and intimacy. And it talks about how AI is entering deeply personal spaces and relationships and emotional support. And that this is not going to fix the loneliness crisis. So firstly, this is not the usual territory for a tech lawyer, even though this is something that's really entering the discourse right now. So what made you want to write about this? But also, secondly, what does this tell us about new kinds of harms that our current regulatory thinking isn't really equipped to deal with?
Yeah. So Nidhi, this is precisely the second part of my previous answer to the previous question as well, which is the fact that, look, even then there will be unique harms that we should be identifying as a society and regulating it. And I believe artificial intimacy is one such aspect. right? And look, so I would say that look, a large part of my life or my practice is to deal with issues such as this, right? So I deal with a lot of similar issues from a product perspective, from a safety perspective, when I practice law. And that's what led me to sort of write about it, and also observing what's happening around us, right? So artificial intimacy is now taking on to a different level, where we are actually forming intimate relationship with computers or AI for that matter. We've all seen the movie Her, but it's actually in practice. And if you just look around you, you will find at least one or two colleagues who's actually hooked on some form of a companionship from an AI provider. It need not be romantic always. It could be a different form of companion as well. To a large extent, ChatGPT is that to a lot of people, right? In fact, there are studies which show that when ChatGPT's tone and tenor changes in terms of response, people get upset, right? So in that sense, I would say that look, we are forming a relationship with AI, and the typical ways in which engagement works, or most of these technologies, the way it works is they're designed to drive more engagement. So that's the reason why when you ask chatbot a question, it'll act like a sycophant and probably just say, "Oh, you're wonderful. This is just blue sky thinking. You're the most intelligent person I've seen." These sort of remarks will sort of revalidate or validate your self worth, and you will continue to engage with them. And sometimes, it'll just ask you a question like, "Look, this is the answer to your question, but do you want me to show something else so that you can do this in the most appropriate or the easiest manner?" This is a ways in which digital tech has always evolved. It has been made to drive further engagement, because everybody is striving for our attentions, right? To borrow someone else's word, it's all the attention merchants that are engaged in this business. And when that is the only motive, when profit is the only motive, when it comes to providing an intimacy as a service, right? Then we will look at naturally a situation where human beings become vulnerable, not just from the perspective of loneliness. As you see, loneliness economy is probably one of the biggest economies in the world. The likes of the OnlyFans to the earlier, phone call conversations to, many video streaming platforms and audio platforms that you see across the globe. They're all part of the loneliness economy. Now AI is supercharging or driving it, which means that instead of humans on the other side, there are these agents who are completely tireless. They're always available. They're always revalidating. They're boosting the dopamine hits much better, and it can be used for all sorts of uses. For instance, it could affect people emotionally. It could be used to target folks and drive them to do certain things which they're not otherwise used to. They could be used to brainwashing. It could be used at a large scale, and it could have national security implications, right? So the way I see this is not just a problem of one individual gluing onto the screen. It's basically about this model where, look, people are being glued onto the screen, and their information could be misused. They could be made dependent on these platforms. They could be made addicted to some of these platforms. So it's time that we start thinking about it. Look, I don't have answers to it, but we are going to face this problem, right? We are going to face this problem very soon, whereby we will see that we are very, very reliant and dependent on the computers. And if we are unable to draw the line, and that drawing line cannot always be done by law, it needs to be done by all the stakeholders involved. Parents should be involved. Counselors should be involved. Mental health professionals should be involved. So what I'm urging in the article is not just to say that, look, we need to regulate it immediately. Is to say that, look, let's understand that this is a problem. If we are just seeing this after 3 years of ChatGPT, where will the scale be of the problem be after, let's say, 5 years? So let's start the awareness about it. Let's start studying about it. Let's start writing and speaking more about it. And maybe in some time, there may need to be a regulation around it. And let's start thinking about how do we marry some of these preference choice regulations, for instance, in terms of dark patterns and other things that we have already have in place for social media and for e-commerce. Let's try and marry that for AI as well. Probably that's where the solution will ultimately lie. So that's why I think, it caught my attention, and I thought I had to write about it.
It's really interesting to look at how AI is kind of infiltrating our everyday personal lives. So having something in your pocket that constantly tells you that you're brilliant, of course, that's going to be addictive. But I also want to talk about how AI is filtering down into our professional lives. So AI is being used a lot at trilegal, and I find that really interesting. And it'd be great to hear from you about it. So, about 75% of your lawyers use AI in their workflows. You've said that you treat AI like a supervised junior lawyer. And you've also previously mentioned that you barely type anymore. You use the voice tools when you're doing work. And the lawyers at your firm are vibe coding, which I had to look up, but it means building prototypes themselves using some of these AI platforms. From the outside in the legal world, that sounds quite wild. But can you tell us what it actually looks like on the inside?
Sure, absolutely, absolutely, and also look, I think the 75% figure is, what we are talking about. 75% figure is basically the extent of adoption of a particular tool that we use within the firm. I'm sure in terms of general purpose tools, the adoption will be 100%. I'd be surprised if it's not 100%, right? We are largely a firm which is very tech forward, and most folks here use technology one way or the other. So it should be 100% if you include the shadow AI usage as well. So what that means, look, is that look, we are able to infuse AI into our workflows, which means that there are a large number of tasks that we were otherwise doing as lawyers, which are not necessarily intellectually rewarding. Going through large number of documents to find specific clauses on change of control at the time of mergers and acquisition to ensure that the appropriate notices or notices or permissions are taken. It sometimes involves a lawyer spending close to around 100 200 hours, and those 100 200 hours are often not even chargeable to the client, because the client will never accept such a big fee. So there are a lawyer's life often involves a lot of these work which cannot often be built out, which is not intellectually rewarding. AI has now helped us make a lot of this supercharged, right? AI has helped us to find information within large documents or large stack of documents. AI is able to put together pieces of information and help us find answers much faster. It has equipped the lawyers to be to operate at pace and scale, which otherwise was impossible in the previous scheme of things. So I would say this is probably, when I started my practice, that was a time when internet was just really becoming big. We are now at that phase where AI is really becoming big in terms of the practice of law, and the disruption that is going to cause to the legal. When I say disruption, I'm not, I mean it in a positive way. It's going to be pretty significant, because the interesting thing about AI or Gen AI at this point of time is it's actually not going to the workforce. It's actually going to the knowledge economy first, right? So it's entered knowledge economy. Law being one of the professions sitting on top of the knowledge economy is getting it's getting changed. It's getting significantly disrupted with the advent of AI. And we in Trilegal we are a firm which embraces change and adopts change. So we've been at the forefront of this right from somewhere in 2022. We've been building our infrastructure, getting ready for this change, and I've been lucky enough to help the firm navigate some of the complexities that we've been facing over the years, by building tools, finding the right set of service providers to work with, finding the right talent within the firm itself to work with. For instance, we have a team of both technologists and lawyers who are engineers, or engineers who are lawyers, or lawyers who wipe code, which means that, look, we speak to Claude, or we speak to Gemini and create code, create some of the prototypes of the products that we work with. Earlier, when we used to develop products, we had to go to, let's say, a designer to get the wireframes made. Now we can make the wireframes with Claude within a matter of, maybe 10 minutes or 15 minutes with proper prompting. We have our own workflows and agentic workflows set within the team to help us assess moving fast when it comes to the daily work that we do. So it's a very interesting phase where we are sort of taking the workflow of a lawyer and getting it charged by AI, helping things move faster, helping us to scale much faster and attend to a client's need at a much faster pace. So that is, it's probably at some level for someone who's a tech lawyer who's deeply into tech myself, I'm an engineering dropout myself. This is at some level a dream come true, right? I mean, I'm surrounded by folks who probably know AI much better than me or technology much better than me. I'm also deeply passionate about technology, so it's fun times, and then that's what I talk about when I say that we have lawyers who vibe code, and it's actually a culture in within trilegal.
So this is so interesting because the internal tool that you've talked about, Trilegal's incubated Lucio, which is a legal platform that you use in-house, and you had the digital innovation group. So the firm is simultaneously building AI tools, it is using AI tools, and it is advising clients on AI risk and regulation. Is there any tension that comes in this? How do you manage that? And how does being an advocate and a watchdog at the same time work?
So look, I would say that I'm always cautious and optimistic at the same time, and that's the reason why I could write about say that look, let's not have an omnibus AI regulation, and then say that look, we should look closely at artificial intimacy. And the fact that I'm doing both is incredibly helpful. The fact that I'm helping the firm chart its digital journey, understand these tools much better, is also helping me advise my clients on these matters. And honestly, look, one of the reasons why most clients come to me is not just for my legal knowledge, but also for my deep understanding of a technology. Because I love tech. Like I said, I've been an engineering dropout. So I could have conversations with product teams. I could have conversations with engineers and scientists. And this is part of what we do at Trilegal, right? So in that sense, I would say that this is an added advantage to our practice. And it's not just me. There are other folks in my team also who wear similar hats at various levels. And they also, in fact, become better technology lawyers because of the fact that they also work on the innovation group at the firm, right? So we have real world understanding of some of these problems when clients come to us. Sometimes we have deeper understanding of technology itself, which will help us not just in telling them, the do's and don'ts with respect to a technology. Also, we help them to modify their products to be compliant with law, right? I mean, that's another skill set that a technology lawyer, a product counsel should bring to the table. And working on both sides, in fact, has helped us on both levels. And look, even when we adopt AI at the firm, while we are an advocate for new technologies, we also have to be cautious, and we also have to be optimistic at the same point of time, because we are dealing with not just our data, we are also dealing with client data. We are dealing with sensitive matters, so we cannot be fully adventurous about the way in which we use technology. So I would say that this is something which is complements and supplements each other very well, and that has really helped both these functions that I do at the firm.
So I'm going to finish this. The last question I'll ask. So I'll ask a slightly harder question. There is a common argument that you get in this space, and it says that you should regulate the harm and not the technology. So you don't ban the tool, you go after the misuse of the tool. And that intuitively makes sense. But generative AI operates at a scale and a speed that is genuinely different from what we've seen before. A single model can produce millions of pieces of harmful content in the time that it would take for you to detect one. So, at what point does the speed of harm generation require us to rethink about regulating the tool itself and not just waiting to address the harm after it happens?
So, Nidhi, let me tell you something which may not necessarily be very popular, maybe amongst the listeners, is the fact that look, I don't think technology is inherently bad or wrong at any point of time. It's really those folks who use the technology or those folks who control the technology, right? So my belief there is that there is no point in just saying that regulating the technology. It's just again the harms, but you can regulate the harms at the origin of the technology itself or at the application of the technology itself. Now, it's a choice that we often have to make when it comes to when to regulate that. What point do we step in? Do we need, for instance, one of the famous examples when I talk about this Collinger's dilemma, which is that look, the dilemma is about if you regulate too early, you kill innovation. If you regulate too late, then it's deeply entrenched, right? The classic case example of early regulation is in fact what happened with printing press in the Ottoman era, where they banned printing in the local language, which led to English and other languages taking over the world when it comes to printing, where and printing as a technology was completely banned there, and the other languages which did not ban it just took over and became the language of trade and commerce across the globe. Whereas if you regulate it too late, you will probably have a situation like in the US, and for instance with guns, right, where it is in fact so entrenched and to become a constitutional right that you cannot regulate it at any given point of time, right? So it's a difficult question to answer given this. And I would say that, look, the answer to AI, to regulating AI scale, lies in AI itself. Because if AI can be used at certain scale to generate content, the same AI can be used to regulate the very same content at scale as well, right? So it's empowering both the perpetrators and the enforcers at the same time. So I would say enforcement is really the key. Strengthening the enforcement is really the key. And the government should really invest in strengthening the enforcement authorities, which I know for a fact with respect to several bodies, including IFOC and other things they've been doing. But we need to do it at a faster scale across various states and union territories levels as well, so that they're equipped to handle with such harms. And I agree, AI is a loaded question. And probably I may have a slightly different perspective when maybe after we meet in a year or two. But till that point of time, this will be my answer to your question.
Thank you so much, Nikhil. With that, we'll come to the end of the episode. Great attempt at answering some really difficult questions, and we'll follow up on this hearing from you in another year and a half and see how your perspective on this changes. Nikhil, thank you so much for joining us. This was a really rich conversation. We covered everything from the nuts and bolts of the DPDP to AI and loneliness and vibe coding lawyers, which is not a phrase I expected to use on this podcast. We'll be back in 2 weeks with a new episode. To make sure you don't miss it, be sure to subscribe on Apple Podcasts, Spotify, YouTube Music, Stitcher, or wherever you get your podcast from. To learn more about our research and team, you can visit us at carnegieindia.org. You can also find us on social media on X, Facebook, and Instagram. Thank you for listening. See you next time.
Thank you.